So welcome to our company law class. So the last time we met, we had started discussion of formation or setting up or incorporation of the company. That is the first part of that discussion. And within the context of that, we also discuss types of companies. So just before we ended, and then we discussed few more things about company limited by guarantee. Now, tonight we will be focusing more on the legal effect of incorporation because last time we discussed the processes which must be gone through in order to have the incorporated company set up. But just before we do that, I would like to discuss briefly Section 9 of the Companies Act 2019 Act 992, which addresses conversion of company limited by shares to company limited by guarantee. So in Section 8, as you recall, we're told that a company limited by guarantee is a company which is incorporated not with the object of making profits. And if it to make profit at all, the profit should be in furtherance of the objects for which it is set up. So not like the kind of profits you make and you distribute for members by way of dividends, as is typical in the case of company limited by shares. So that is company limited by guarantee. And we also noted at our last class that at the start of the company, that is when you are going through the formation and incorporation, members will make undertaking, a solemn undertaking regarding how much they are prepared to contribute towards the debts and liabilities or assets of the company, as it were. And we learned that should it happen that the company is being liquidated, then members will be called upon to come and contribute how much they actually undertook or they guaranteed as far as the debts of the company are concerned. Now, it is permissible for a company which was originally set up or incorporated as a company limited by shares to be converted or to be changed to company limited by guarantee. So it's possible to convert company limited by shares to company limited by guarantee. And that is what Section 9 of Act 992 seeks to make us aware. And before a company limited by shares, just in case you have forgotten company limited by shares, we said that is where members or the shareholders their liability is up to the amount of money which they have paid for the shares or they're supposed to pay for the shares they hold in the company. And once they are fully paid for the shares, if the company is even liquidated, all that is stand to lose is the money that they paid for the shares. And if they say that nobody will ask them to come and pay any more towards the debt. On the other hand, if a member has not finished paying for the shares that have been issued or allotted to him, then that person will be called to pay the unpaid value. So that is the only thing. But if you fully paid, then should things get rough, all that you stand to lose is the money that you have put in the company by way of the value of the shares that you have. Now, you may want to get that type of company to be converted or translated to company limited by guarantee. And in that regard, there are some rules which must be observed. So Section 9(1)(a) will tell us that to convert a company limited by shares to company limited by guarantee, there should be no unpaid liability. In other words, the shares which have been issued should have fully be paid. It shouldn't be the case that you have shareholders who are still owing in respect of the shares that were given to them. So that is the first rule. The second rule in terms of section 9(1)(b) is that all members of the company limited by shares desirous of converting it into company limited by guarantee must enter into written agreement, not oral agreement, written agreement, or they should agree in writing that they would like to have the company limited by shares converted into company limited by guarantee. And thirdly, the agreement must also reflect their willingness, that is, their voluntariness to transfer or to surrender to the company for cancellation of the shares held by them. So if you have shares, it's an investment that you have. It's a sort of like a property, especially so when you are fully paid for the shares. Meaning that you can will your shares, you can give it as a gift, you can sell it if it's not a company, if it's not a private company, as we learned last time. In which case there are some restrictions on the transfer of shares. But if it's a public company, you can sell your shares to any willing purchaser, as it were. So that means that having shares is something significant, something substantial. Therefore, if the company limited by shares is going to be converted to guarantee, the lawmaker would like it to be from the free will of the shareholders, because they are going to lose money, they are going to lose the investment. And that is why it is a rule that you must sign a written agreement and also voluntarily surrender, that is, give up your shares to the company. And then the company will cancel your shares. When your shares are canceled, the money will not be refunded to you because you have voluntarily surrendered it. So it will still remain in the company, as it were. A new constitution, which is suitable for company limited by guarantee, will have to be adopted. That is, if, yes, you have to be adopted. And members of the company limited by shares, which is on its way to becoming company limited by guarantee, must agree in writing again to contribute to the assets of the company in the event of the company being wound up to an amount of money not less than that prescribed by section 8(3). So we have to keep that in mind. When we say like section 8(3), if you remember, section 8(3) is simply to the effect that the total liability of the members of the company limited by guarantee to contribute to the assets of the company in the event of the company being wound up shall not at any time be less than the amount of money specified in the application required for incorporation. So the money that you stated that you are prepared to contribute, if the company is being forced to close down, that is what we are referring to here, that yes, if you are going to convert company limited by shares, company limited by guarantee, among other agreements, you must also state how much you are prepared to contribute towards the assets of the company and eventually any liability which the company may have when it is being liquidated or wind up. So once all these things are done, you submit the agreements and the paperwork to the Register of Companies, and the director of the company and the company secretary will swear statutory declaration, which we explained the last time, a solemn statement pursuant to the statutory declaration as of 1971, by which you make oath and say that the things that you're saying are true. And if it happens that they are not true, you have committed the offense of perjury, and there could be penal consequences for you. Good. So when all those things are done, the Registrar of Companies will issue a new certificate of incorporation to the effect that the company is limited by guarantee. So that which used to be company limited by shares will have now metamorphosed into company limited by guarantee. So let us keep that in mind. Yeah, so you read the rest of the provision, but we will continue to discuss the legal effect of incorporation. Okay, so the last time we also discussed the mechanics of incorporation, the practical things one needs to do to get an incorporated company, to get the company registered. So we talk about a number of things, and with respect to section 14, subsection 1 of Act 992, we made the point that where the Registrar of Companies is satisfied that the application for incorporation of a company complies with all the requirements and prescriptions of the Companies Act. Once the prescribed fee has been paid by the subscribers, those who are submitting the documents for incorporation, they are called the subscribers. Once the payments have been made, the registrar would now have to legally acknowledge and proclaim that the company is duly incorporated. And how is that done? That is done by the registrar issuing certificate of incorporation, and who put his seal on it. And if it's a company limited, it will indicate that yes, the liability of members is limited, as we discussed at our last class. But more importantly, if we look at section 14, subsection 2, it makes the point that from the date of incorporation, the company becomes a body corporate. It becomes a body corporate by the name contained in the application for incorporation. And of course, subject to section 13, is capable of performing functions of an incorporated company. So, when the certificate of incorporation is issued, legally the company is born into existence. So it becomes a corporate person. But mind you, the mere fact that you have submitted your application does not clothe the company with corporate personality. The certificate of incorporation must be issued. And maybe let us also make the point that, in the past, that is under the old, the repealed Companies Act, 1963 at 179. In addition to certificate of incorporation, there was also something called certificate for commencement of business. And in those days, when you have been given the certificate of incorporation, you are not ready to start transacting business using your new corporate vehicle. You needed to also get the certificate of commencement of what? Of business. But all those things have changed. So now we just simply have the certificate of incorporation. So certificate of incorporation, as we have stated, evidences the fact that the company has come into existence in the eyes of the law. And if you look at section 15 of the Companies Act, the certificate of incorporation is said to be a conclusive evidence a conclusive evidence that the company has duly been incorporated under Act 992. When we say conclusive evidence as opposed to prima facie evidence, what it means is that, yes, it is a closed book, or there's finality regarding the status of the company being incorporated. So the law recognizes that, yes, everything that needs to be done is deemed to have been done. So the company has come into existence. And that is why Section 15 will further make the point that once certificate of incorporation has been issued, proceedings shall not be brought in court to cancel or annul the incorporation. So you cannot, for example, say that, oh, one of the subscribers was an infant, has not attained 18 years. And for that matter, the certificate of incorporation should not have been issued. So it should be annulled or should be cancelled. No, because Section 15 says that the certificate of incorporation is a conclusive evidence. It's a conclusive evidence that the company has properly been incorporated. So let us keep that in mind. Just imagine if that were not the case, we will get a situation where people, like, a company which is set up running its business will just be inundated with the unnecessary litigation, people challenging that maybe certain things were not properly done. And for that matter, the company should not have been incorporated in order. And that is why the lawmakers, in their wisdom, said that the certificate of incorporation is a conclusive evidence of the due incorporation of the company. So let's keep that in mind. But saying that it is conclusive evidence does not mean that if for good reason proceedings need to be brought for the winding up of the company, that cannot be done. So if you look at Section 16, we'll be told that despite the fact that Section 15 is saying that the certificate of incorporation is a conclusive evidence of the company being duly incorporated, that does not detract from the separate legal arrangements we have, for example, under Section 274, which says that under appropriate circumstances, proceedings may be brought to the court, either pursuant to the Corporate Insolvency and Restructuring Act or by a private liquidation, as the case may be. So let us take note of that. So at this stage, we would like to explore, we would like to examine the consequences of incorporation. Consequences of incorporation. And before we delve further into that, I would like us to remind ourselves of the case I've asked you to read, the case of Solomon and Solomon. Would anybody volunteer to walk us through that case? Okay, so in Solomon and Solomon, as we have said, reported in 1897 AC, page 22, very important decision of the laws because it laid down the very principles for the modern company law as we have. Yes, somebody wanted to talk. Who?
Yes, sir. I wanted to
Mention your name.
My name is George Asara. I'm speaking from the SEPERATE.
Oh, SEPERATE.
I want to talk about the Solomon.
Okay, good. We wish you a speedy recovery.
Yeah. Thank you very much. Yeah, it was a case that was initially it was Mr. Solomon who converted his sole proprietorship business into a limited liability company. And the company had almost 7 members and himself. So he floated shares among him, his family. Okay. Later on, Mr. Solomon, he sold his company to, he sold his business to a company and inflated the prices to a certain amount, and he was paid. After that, the shares were shared among the family and Mr. Solomon himself.
All right. Thank you very much. That's a good attempt. Yeah. So we used to have Mr. Solomon, who used to have boot and shoe manufacturing business, and as our friend rightly said, he used to do this business, as a sole proprietor. That is, he was unincorporated. He was just on his own, as we have discussed the various models or forms of business organizations. There's no separation between his income, his affairs, his liabilities, and that of the business. So that is how Mr. Solomon was actually running his business. Now, he had done this for over 30 years. He had done this business as sole proprietor for over 30 years. And in the course of time, he decided to take advantage of the Companies Act of 1862, which permitted general incorporation to be done. So he decided to register and get his sole proprietor business incorporated so that we become like an incorporated company. And in those days, you needed to get the 2 constitutional documents, the Memorandum of Association and Articles of Association. And all these things were done. And the capital of the company, the stated capital of the company, was supposed to be £40,000. And this was expected to be divided into 40,000 shares, as it were, so that 1 share is worth £1, or £1 will give you 1 share. Again, there was articles of association, and all that need to be done was actually done. First directors were selected by Solomon himself, and again, Mr. Solomon also had it, the company organize a general meeting, and they decided to borrow money using debentures. And the resolution or the understanding they had in the company was that the borrowing cannot exceed £10,000 if they really wanted to do that, unless there had been like a general meeting, as it were. So this was meant to be private company, as it were. So the private company that we discussed, we have no restriction on membership, you can make invitations to the public, and all the things that we have discussed. Who were the subscribers to the constitutional documents submitted for registration of the company? Mr. Solomon himself, his wife, and 5 of his children, who were all grown up. So the subscribers met and appointed Mr. Solomon and his 2 elder sons as directors. and directors then proceeded to carry out a proposed transfer. So they made an agreement, and the company adopted the agreement in accordance with which the business of Mr. Solomon, which he was doing as a sole proprietorship, was actually taken over by the company, which has now come into existence. So from 1st June 1892, that which used to be one-man business of Mr. Solomon in the vicinity for over 30 years was no longer so. It was now seen as a company, A. Solomon and Company Limited. They had now taken the business. Nothing had actually changed. Everything remained the same, just the legal arrangement. So that was the situation. And they valued the business of the sole proprietorship as, if you like, a little over £39,000. So mind you, they had actually put 40,000 as a stated capital when they registered the company. And now they are selling the business to the new company. So when they sold the business, some of the, of course, Mr. Solomon got the money and he used the money to also pay for shares, which had been given to him. And so they gave actually 20,000 to him, and he used that money to buy shares. So don't forget, the shares were 40,000 and one share was £1. So if Mr. Solomon had been given 20,000 and he's using all to buy shares, Mr. Solomon was going to get £20,000, 20,000 shares. So that is what he got. Then the company was still supposed to pay him 10,000, and the 10,000 was actually paid in debentures. That is to say that they treated the 10,000 as a loan, which Mr. Solomon has given to the company. And it was 11,000. And then the £1,000 was actually paid to Mr. Solomon in cash, as it were. So this was the state of affairs, but things became rough, and evil days fell upon the business. Not too long after the company had taken over the business of Mr. Solomon, there seemed to have come a period of Great Depression in the boot and shoe trade, where generally demand had gone down. People were not buying things as it were. So you even produce, nobody is actually buying. So this was unfortunate for Mr. Solomon, and then Mr. Solomon and his new business, as it were. Again, there were strikes of workmen. People embarked on various strikes, and things were just rough, meaning that business was not going on well. And Mr. Solomon, most of the work that the business they were doing, they used to supply on public contract, like to the public sector. So these strikes all affected the business of Mr. Solomon, as his income actually went down. So Mr. Solomon made effort to try and look in other direction, but all those things were not very successful. So Mr. Solomon eventually decided to have his debentures, that is a loan that he had given the company, cancelled. And he reissued it to one Mr. Broderick. So Mr. Broderick was said to have advanced £5,000. So that was handed over to the company on a loan. And this, of course, brought a little bit of relief to the company. Mr. Broderick, who had given this loan to the company, was supposed to be paid interest, but his interest was not paid when it became due. So Mr. Broderick got angry that his money was actually getting lost. So he took proceedings at once and got a receiver appointed, an official appointed. And the official triggered liquidation and a forced sale of the company's assets. And the receiver, as a liquidator now, having started the sale of the assets of the company, was able to realize some money to pay Mr. Broderick. But the money was not enough to pay the debentures in full and other unsecured creditors. That is other people who had either given materials and other things to Mr. Solomon's company on credit, but they haven't taken any security as such, but the company was still owing them. So the assets realized by the liquidator were not enough to be able to pay all these creditors. So in this state of things, the liquidator met Mr. Broderick, that is the main, if you like, creditor, met Mr. Broderick's claim by a counterclaim, to which he made Mr. Solomon a defendant. And he disputed the validity of the debentures on the ground of fraud. So the liquidator sought to challenge the legal validity of the loan arrangement called debenture, and he thought that it was tainted with fraud, and for that matter, it should not be, given the legal recognition, and it should not be upheld. So the case presented by the liquidator broke down completely, but the judge who presided over it suggested that the company had a right of indemnity against Mr. Solomon. That is Mr. Solomon, who was responsible for this, seemingly fraudulent arrangement as far as the debenture was concerned, had actually made the company incur a loss. And the judge was saying that, well, if anything at all, the company can sue Mr. Solomon personally. So the company was Mr. Solomon in another form, and it was said that he has used his name as an alias, for he had employed the company as his agent, because all that he was doing was just doing the same thing. So the court was saying that if Mr. Solomon was using the company as his agent, then he was like the principal. So if the debenture and all that is deemed invalid, then whoever is affected can actually pursue it against the company. But the judge was saying that, well, the company and Mr. Solomon, there's no really difference, because he's just using it as an extension of himself. So this was the state of affairs at the court below. So the order of the learned judge, that is the trial judge, eventually when the matter came before the House of Lords, Lord Magneton speaking, took the view that the trial judge seemed to have misunderstood, or seemed to have had a misconception of the Companies Act of 1862, because how he reasoned is against the spirit of the Companies Act. In Lord Magneton's view, the Companies Act of 1862 requires that a memorandum of association should be signed by 7 persons who are each to take 1 share each. If those conditions are complied with, what can it matter whether the signatories are relations or strangers? And Lord Magneton will make the point that there is nothing in the Act requiring that the subscribers to the memorandum should be independent or unconnected, or that they or any one of them should take substantial interest in undertaking. So all that His Lordship was trying to say was that there was absolutely nothing wrong by having Mr. Solomon and his children and his wife being the subscribers and the shareholders and the directors. Because if you look at the Enabling Act, that is the Companies Act of 1862, there was nothing in it which actually forbade that. So Mr. Solomon had done nothing wrong, which should deprive him of the legal form and the legal effect, which compliance with that legislation give. That is the status of what? Incorporation, the status of a separate legal personality, as it were. Now, His Lordship will continue, and he will eventually make the point, which will come to what we are discussing. If you look at the portion of his judgment, Lord Magneton will make a point that the company is at law a different person altogether from the subscribers to the memorandum. And though it may be that after incorporation, the business is precisely the same as it was before, and the same persons are managers, and the same hands receive the profits, the company is not in law the agent of the subscribers or trustees for them, nor are the subscribers as members liable in any shape or form, except to the extent and in the manner provided by the Act. So Lord Magneton was underscoring a fundamental principle, which is actually the foundational principle of modern company law, the principle of separate legal personality, that the company so incorporated is considered in the eyes of law as a juristic person, as a persona separable from the incorporators, from the shareholders, from the subscribers, from all officers, and so on and so forth. So that is the takeaway, that upon incorporation, the company acquires a separate legal personality. Of course, similar point would many years later be commented and approved by our Supreme Court in Moko versus Kuma, as you remember. Moko and Kuma, as you later on read. And I'm getting worried because if I ask you to read cases, you seem not to take it serious. But being in the 3rd year of legal education or 4th year, when you are asked to read something, it's enough for you to go and read it. We don't have to police you again, because at this stage, you are supposed to appreciate the importance of reading judicial decisions in order to better understand the law. So in Moko and Kuma, very interesting case, a case which ordinarily was just, if you like, a matter of a summary judgment. Also encountered company law, the principle of separate legal personality. What were the basic facts of Moko and Kuma? The plaintiff entered into a sale agreement with the first defendant company, East Coast Fishes Limited, for supply of certain amount of frozen fish. And the sale agreement was negotiated and witnessed by the second defendant, that is Kuma, the second defendant, who is also happens to be the chief executive officer, like the CEO of the company. He did the negotiation and signed all the paperwork. And interestingly, the CEO was also the director and the shareholder of the company. So the company paid a deposit for the transaction and promised to pay the balance of the purchase price by a certain period. The period elapsed and the company defaulted in settling the balance of the purchase price. So the plaintiff decided to sue both the company and the second defendant. The second defendant was the chief executive officer. So he sued the company and then the CEO, who also happened to be like the shareholder and the director of the company as well, for the outstanding balance of the purchase price. So eventually, judgment was entered against them on summary judgment. Then the matter went on appeal. And when it went on appeal, the Court of Appeal, by majority, that's a 2-1, dismiss the appeal. Of course, before the Court of Appeal, the trial court, that is the High Court, when it gave its ruling on the summary judgment, actually failed to comment on the propriety of making the second defendant, the CEO, also a party to the suit. And when the matter came to the Court of Appeal, by a majority of like the 2-1, the court dismissed the appeal on the grounds that the circumstances of the case justify the lifting of the veil of incorporation. So the Court of Appeal appreciated the company law point, but they also look at it from a different angle, which is that the veil of incorporation should be lifted. That is, the principle of separate legal personality should be sidestepped, should not be followed. And if it is not followed, then we will come to appreciate that the CEO, who is also the shareholder and the director, is actually the one who eventually did the transaction and benefited. And if there's a default, he should be made to pay, as it were. Now, the matter did not end there. It went further to the Supreme Court. And eventually, the Supreme Court made the point that since the appellant had been jointly sued with the first defendant, a limited liability company, for the only reason that she was the chief executive, the main shareholder, and the director of the company, should be a proper party to the suit only if a specific personal liability were established against her against her, or the veil of incorporation could be lifted to make her as synonymous with those of the defendant company, or vice versa. So the Supreme Court is saying that it is wrong to simply sue the CEO, who happened to be the majority shareholder and the director, alongside the company. And you could only do so if there were good reasons for actually lifting the corporate veil. And we'll be discussing lifting of the corporate veil pretty soon in the course of this topic. So let us keep that in mind. And please read the cases. So the legal effect or the consequences of incorporation, we have seen that the company acquires a separate legal personality. It also acquires the capacity to contract, because if it's a legal person, then in the eyes of the law, what a natural person can do, the company can also do. The company can enter into contractual arrangement, various transactions. The company can even commit tort. The company can also commit crimes through the directors or the officers, as the case may be. So the company has the capacity to contract. So that is the point to note. And if you look at the case of Lee against Lee Air Farming, it's a very interesting case. So I entreat you to read the case of a Lee against Lee's air farming, just to illustrate the point that the company has the legal capacity to enter into what? To enter into contract, please. If I'm to discuss all the cases with you in detail, you will never finish even one topic. So if I ask you to read, please make effort and read. And the cases are actually nice. You enjoy them. They are not boring at all. Very interesting cases. So in Lee, against Lee's air farming, Lee, the appellant's late husband, had formed a company, that is a respondent company, Lee's Air Farming Limited, to carry on his business of spreading fertilizers on farmland, what we call the top dressing from air. Use something like aircraft device to be spraying from air. So the appellant's late husband held 2,999 of the 3,000 shares in the company, and was also appointed as the sole governing director. And he was also employed as the chief pilot at a huge salary. Unfortunately, Mr. Lee was killed in an aircraft crash while flying for the company, while he was doing the top dressing using the aircraft. Now, if Mr. Lee was understood as a worker, defined as any person who has entered into or works under a contract of service with an employer, then under the Workmen's Compensation Act of 1922, his widow was entitled to be paid compensation by his employer, because that is what that legislation sought to do. But before his widow would be entitled to claim compensation on behalf of his late husband, it must be demonstrated that the late husband was a worker or employee as understood under that workmen compensation legislation. The company, as required by law, was insured against liability. So he had insurance policy to pay its workers such compensation. So Mrs. Lee appealed against a ruling of the Court of Appeal of New Zealand that Lee could not be a worker when he was in effect also the employer. So the New Zealand Court of Appeal had taken the view that if you look at the whole thing, Mr. Lee was having 99.9% of the shares in the company, and he was also the chief pilot. And he was also like the governing director of the company. So the New Zealand Court of Appeal has taken the view that in that respect, Mr. Lee was the employer. And if he was the employer, he could not employ himself. So he didn't have the status of a worker. And if he didn't have the status of a worker, the wife could not actually claim compensation under the Workmen's Compensation Act. So the appeal came to the Privy Council, which used to be like the highest appellate court for New Zealand, just like many other Commonwealth countries. And in the Privy Council, Lord Morris of Border Guest delivered opinion on the court and held, among other things, that the New Zealand Court of Appeal recognize that a director of a company may properly enter into service agreement with his company, but they considered that in the present case, in as much as the deceased was a governing director in whom was vested the full government and control of the company, he could not also be a servant of the company. So their lordships at the Privy Council reacted to the New Zealand Court of Appeal decision along the following ones, quote. Now the Privy Council is speaking now. Their lordships find it impossible to resist the conclusion that the active area operations were performed because the deceased was in some contractual relationship with the company. That relationship came about because the deceased, as one legal person, was willing to work for and to make a contract with the company, which was another legal entity. And this is what is of importance to us. See that the court is emphasizing the fact that, despite the fact that Mr. Lee had virtually all the shares, 2,999 out of the 3,000 shares of the company. He was also like the director. The court was saying that the company was a separate legal entity. A contractual relationship could only exist on the basis that there was a consensus between the two contracting parties. It was never suggested, nor in their lordship's view, could it reasonably have been suggested that the company was a sham or a mere simulacrum. It is well established that the mere fact that someone is a director of a company is no impediment to his entering into a contract to serve the company. If then it be accepted that the respondent company was a legal entity, your lordship see no reason to challenge the validity of any contractual obligation which were created between the company and the deceased. Yeah, so the most important takeaway is that their lordships recognize that, yes, the company was separate, and if that is so, there was nothing wrong for a contract to be entered into between the company and the late Mr. Lee, regardless of the fact that he was virtually the majority shareholder. So let's keep that in mind. And again, we have to remember that the company, being a juristic person, is an artificial legal person. The company does not have hand, it does not have legs, it doesn't have mind. The company acts through natural persons, through its officers and members and agents. And that is why, if you look at section 144(1) of Act 992, it will provide that a company shall act through the members of the company in general meeting or the board of directors, or through the officers or agents appointed by or under the authority derived from members in general meeting or board of directors. So yes, the company is a legal person, but it acts through natural persons. So let us keep that in mind. Another consequence of incorporation is that there's limited liability and also separate property. The company, being a legal person, has the capacity to acquire assets, to have property. And also, the members can also cap their liability. Members are not liable for the debts and liabilities of the company. The debts of the company are the debts of the company. They are not the debt of the members or the directors, as the case may be. So as we have discussed, company limited by shares and guarantee, all that we have discussed in previous classes with respect to that are also applicable here. But of course, we also have unlimited liability company, in which case they have no capping of liability, although the company enjoys what we call the corporate status. So you look at the case of especially ruled steel properties against the British Steel Corporation, and we've also made a point that the company has the capacity to acquire property, and that property is the asset of the company. It's not asset of the members or the officers. So the property or the assets of the company are separate from that of the members. So that is very important. So if, for example, some people, they would like to register companies and they will give most of their properties to the companies and all that, so that if you see them, you sue them personally, it becomes difficult for you to get assets against which you can levy execution. So as you will encounter later on the case of Prest against Petrodor Resources Limited. So another point which we need to also reiterate is that as was held in short against Treasury Commissioners, shareholders are not, in the eye of the law, part owners of the undertaking. So the undertaking is something different from the totality of the shareholding. So if you're a shareholder, don't say that I'm a part owner of the company. No, conceptually, that is flawed. Again, a company has the capacity to enforce claims owed to it in its own name. And this is the point that as future lawyers, you need to appreciate. If the company has suffered the wrong, the company must sue in its own name and not in the name of managing director or the name of anyone. So previously, you see some lawyers, they will, for example, sue Quintas Limited per Opanyi Kwakumenu, the managing director, against SYZ school. I mean, that is wrong. If you say the company pays someone, because the company is a legal person, being a legal person, unless it has given power of attorney to someone to represent it. Otherwise, it is wrong for you to use the pay. The company can enforce claim owed to it in its own name. So let's keep that in mind. And indeed, in the very old case of force against Habotel, an early 19th century decision, the view was actually expressed by the English court that where a wrong is done to a company, it must sue in its own right and capacity. Similarly, if we look at our Companies Act of 2019, particularly Section 200, subsection 2, the company can sue or litigate if it has in all rights, like maybe the company can sue, the board of directors would authorize proceedings to commence or be defended in its own name. So I would like you to look at section 290 to section 292 on service of documents, okay? How documents are served on companies as far as legal claims or proceedings are concerned. So if you look at section 200, legal proceedings to enforce liabilities, look at particularly subsection 4. And then you look at section 290 to 292, service of documents. I'd like you to read that on your own. But we also have what we call the derivative suits and actions commenced by registrar upon investigation. Derivative suits, that is to say that an action, like for example, a director who has breached his duties, and the company should have, for example, taken it up, but because the board of directors are those who have to call the shot if they are not doing it, and the member decide to, for example, take up the action. Now that action which the member is taking up is an action which is usually a wrong against the company. The company should have taken it up. So it becomes like a derivative action, as it were. And if you look at the section 201 and 204, there are various rules regarding how a suit which ought to have been taken over by the company is pursued by a member. So somebody should read section 201 for us. 201.
My lord, section 201. Hello, my lord.
Yes.
Section 201. Derivative actions. 201.1. Subject to subsection 3. The court may, on the application of a member or director of a company, grant leave to that member or director to A. Bring proceedings in the name and on behalf of the company or a subsidiary of the company, or B. Intervene in proceedings to which the company or any related company is a party for the purpose of continuing defending or discontinuing the proceedings on behalf of the company or a subsidiary of the company, as the case may be. Please, may I add the two?
Yes, add the two.
2. Without limiting subsection 1, in determining whether to grant leave under that subsection, the court shall have regard to A. The likelihood of the proceedings that may follow. B. The cost of the proceedings in relation to the relief likely to be obtained. C. Any action already taken by the company or a subsidiary of the company to obtain relief. And D. The interest of the company ended or discontinued, as the case may be.
All right, thank you. So the point about derivative action, as you heard from the opening where the chapeau of section 201, that is subsection 1, is that it is a case or an action which will have been taken by the company itself in its name. But as we have indicated not long ago, the company acts through its members in general meeting or board of directors, as it were. So if the board of directors who are supposed to lead the company to litigate, or members are supposed to pass a resolution at general meeting that a certain litigation should be embarked upon to safeguard the interest of the company, if all those who are supposed to take these steps are not acting for various reasons, either because somebody is trying to manipulate the system for their own selfish interests and agenda and all that, the law permits a member or a director to go to court and seek leave, seek permission of the court to use the name of the company to sue, or where there's a certain pending suit involving the company that is suspected that those who are supposed to represent the company, they are not effectively representing the company, and they are just trying to allow the interest of the company to be jeopardized. You can go to court, and the court will give you leave for you to use the name of the company or to stand in for the company. And if any expenses are incurred, you will be permitted by the court subsequently to have it reimbursed by the company. So that is a derivative action. But later on, when we are discussing directors or corporate governance, we'll come back to it. At this stage, we are only trying to make the point that the company has capacity to sue to enforce its claim. However, where those who are supposed to lead the company to sue to enforce its claim are not acting or are not doing the needful, then a member or a director could trigger the provisions on derivative actions and embark upon derivative suit or action to safeguard the interests of the company. Of course, the reverse is also true. The company, just as the company can be a plaintiff or an applicant, the company can also be a defendant or respondent. The company can also be sued. So that is very important. For example, later on when we are discussing protection of minorities, there's something called the remedy against oppression and illegality under section 218 and 219, where the affairs of the company are being run in a manner which a person considers oppressive to his interests or prejudicial to him or her, or things are being done in the company which constitute illegality. It is permissible for an aggrieved member, as it were, to go to court for the court to intervene against the company. Another consequence of incorporation is the element of perpetual succession. Perpetual succession, that is to say that because the company is a separate legal person from the natural persons, the company can potentially exist forever, although it may change its operations. There are some companies which you can trace to more than 100 years, more than 150 years, even some probably 200 years, because the company enjoys perpetual succession. The shareholders will die, directors will die and go and all that, but the company will remain. The company remains. So, if we look at the section 41, for example, somebody should read section 41 for us.
Section 41 says companies ceasing to have members. If at any time a company ceases to have a member and it carries on business without at least one member, every person who is a director of the company during the time that it so carries on business is jointly and severally liable for the payment of all the debts and liabilities of the company incurred during that period.
There is section 171 as well. Section 171.
Number of directors. 171.
Yes.
1. A company incorporated after the commencement of this act shall have at least 2 directors.
Yes, such as
one of these directors.
Subsection 2.
Oh, okay. Okay. Subsection 2. If at any time the number of directors is less than 2 in contravention of subsection 1, and the company continues to carry on business for more than 4 weeks after that time, the company, the director, and each member of the company that is in default is liable to pay the registrar an administrative penalty of 25 penalty units for each day, during which the company so carries on business after the expiration of the 4 weeks without having at least 2 directors.
Good. So, section 41 is telling us that yes, the company can have 1 member. However, should it happen that the company has 0 members, like that is to say that we don't even have 1 member, and the company is still running its operations, and it goes on for a period of time, then during the period that the company actually ran without having a member, if debts are incurred, the directors or whoever presided over the company, when the company was running business without having even a single member, will personally bear responsibility or liability for the debts, and the debts will not be visited upon the company. So that is the point to note. That is the point to note, that yes, it is possible for the company to continue to exist even without any member. However, if the company does not have any member for a period of more than 6 months, you see, I would like you to, I am looking at the old law. If you look at the old law, that is the repealed at 179, the equivalent of section 41 is section 38. And maybe just before we move on, there's something I need to teach you so that when you are learning, you'll be able to, let me see. Good, let me go here. There's something I need to teach you regarding the law. So let's go here first. Look, take your Companies Act or look at the screen. Look at, if you can see the screen. Let me show you something. Good. Good. So please look at the screen. I'm showing you something. That's important. Good. So in your Companies Act, you see this table there called the comparative table. Okay. It's very important because substantial portion of the old Companies Act or the repealed Companies Act at 179 has been reenacted in the new Act 992, meaning that the commentary and discussion regarding the old provisions, the case law around them, are still applicable to those provisions which have been carried over into the new legislation. So if you look at this table, for example, we have the first column, the old or the repealed at 179, okay? And then the next column, we have the bill, which eventually became like the current Act 992. So we are talking about section 41 now. So let's look at 41. So if you look at here, where the cursor is, section 41. If you look at the left, section 38. So if you go to the repealed Companies Act, that's at 179, we have section 38. And I have my copy here, so just listen to how the section 38 sounds. So the topic is company ceasing to have members. Quote, if at any time a company ceases to have a member and it carries on business for more than 6 months without at least 1 member, every person who is a director of the company during the time that it so carries on business after those 6 months is jointly and severally liable for the payment of all the debts and liabilities of the company incurred during that period. Somebody should read the current section 41, which is the equivalent version of the old section 38 that I just read. Somebody should read 41 and I'll show you something.
If at any time a company ceases to have a member and it carries on business without at least one member, every person who is a director of the company during the time that is so carries on business is jointly and severally liable for the payment of all the debts and liabilities of the company incurred during that period.
Wonderful. My reader, can you tell me the difference between what I read and what you have read?
I had six ones, the one that
Absolutely.
you read.
Yes, if we were in classroom, I'll buy ice cream for you, but
Thank you.
they are far apart. So we just clap.
That's great.
Okay, yes. So that is the change. So if you look at it under the old law, a time or grace period was given that if for whatever reason the only member or all the members of the company leave the company, they die or they leave the company, there's a grace period of 6 months within which you must populate the membership, you must get members for the company. Otherwise, you have to take steps to actually liquidate the company. Failing which, if you continue to use the company to run business, then if you're a director and you're cognizant of that and you preside over the company running business when they don't have any member, you are going to bear personal liability for any debt which have been incurred. But if you look at the current provision, that is the section 41, which is the re-enactment with modification of the section 38 of the repeal at 179, you notice that the lawmaker has taken the grace period away. So meaning that it is not acceptable for the company to run business when they do not have even a single member. And this has implication. If you have like the only shareholder, the person dies quickly, the personal representatives and all that, or those who are supposed to be the beneficiary of the estate, the shares and all that, will have to take the necessary step and come in. Otherwise, if it continues to run business, liabilities may have to be borne. So let's keep that in mind. Of course, when it comes to director sue, we noted how a company must have at least two directors. And if it happens that the company is running with less than two directors, the director, the remaining director, who superintended over the company when the company was running operations or business with less than the minimum number of directors, will bear personal liability for any debts or which will be incurred during the period that the company ran without the minimum number of directors. So let us keep that in mind. Also read the case of Formalities and another against the Plastico number 2, very interesting case. Again, incorporation allows company to raise capital by borrowing through the creation of debentures and all that. I will discuss more. It is also possible for a company to acquire back shares from shareholders. Later on, we are discussing what we call the doctrine of capital maintenance in shares. We'll say more things about this. Of course, being a legal person, the company, every person pays tax. Natural persons will pay tax. The company also pays the corporate tax. So what is the current corporate tax percentage against the corporate profit? What is the percentage? Corporate tax, what is it? What is the rate?
25%.
25%. Okay. So the company's profit and fourth will be taken by the state through tax. Now, shareholders, you get your income in the form of dividends, but tax will have to be paid on it, which is different from the corporate tax. So that one, you pay tax on it as a result of you getting your income. Okay, so we will draw the curtain down here, and our next class will discuss lifting the corporate bill. So that will be Saturday. Yeah, somebody wanted to ask a question. Okay, in absence of question, then have a good night.
Thank you, sir.